Welcome. Glad to see you here today. I'm going to let you get started with your logging in, getting situated in the Zoom room. And once you do that, it would be wonderful if you would use the chat to introduce yourself. Tell us what your name is, what's your Yale affiliation, where are you Zooming from, and we would love to also know what made you interested in today's presentation. We save the introductions and share them with our presenters when the presentation is over, but they also get a chance to see your introduction in the chat, and that helps them know, because they can't see your beautiful faces, it helps them to know who they're talking to. So whenever you're ready, if you would, please introduce yourself in the chat. What's your name? What's your Yale affiliation? Where are you zooming in from? What brought you here today? We would really appreciate it. Our numbers are still climbing. Hi to Herman in Chapel Hill. And hi to Maria, one of Jim's classmates. Jim is from the Yale class of 1985. And so I know that all the classmates were invited. So it's great to see you here. Hi to Elliot, Yale College class of 93 from Marietta, Georgia.
Oh,
And Elliot heard about this topic on NPR. Hi to Sarah. No Yale affiliation. You are still very welcome here. We love to connect with friends and family and a broader community of folks who are interested in Yale scholarship. Hi to Heather, Heather, we have to shout you out. That's Jim's wife and biggest fan, class of 80. Hi to Antonio, New York City Yale class of 79, who is active in conservation issues. Please keep your introductions coming. Hi to Nancy Wright from the Yale Divinity School. Nice to see you here, Nancy. Focused on the rights of water and unceded land of the Tunsis people. I hope I'm saying that right. Nancy's in Bloomfield, Connecticut. So, yep, please keep your introductions coming. Meanwhile, I'm going to introduce Professor Salzman. Jim Salzman, class of 1985, alum of the university, is the Donald Bren Distinguished Professor of Environmental Law with joint appointments at the UCLA School of Law and at the School of the Environment at UC Santa Barbara. An international expert on drinking water, he frequently appears as a media commentator and has lectured on every continent. He's a popular lecturer on our Yale Alumni Academy travel programs, and he has twice been voted Professor of the Year by students. He's taught as a visiting professor at Yale, Harvard, and Stanford, as well as universities in Australia, China, Israel, Italy, Portugal, and Sweden. And that means that Professor Salzman is wonderful for us with Yale Alumni Academy travel because he's been so many places. He is also a prolific author. There have been over 115,000 downloads of his broad-ranging scholarship from around the globe on topics such as water, wildlife, climate change, and creating markets for nature. His latest book is called Mine: How the Hidden Rules of Ownership Control Our Lives. It was listed by the Financial Times as one of the top 5 nonfiction books of the year. You can purchase a signed copy of Mine today via the Yale Bookstore. We will be providing you a link in the chat. And you can also travel with Professor Salzman this fall on Cruising Singapore to Bali, Journey Through the Java Sea aboard the Heritage Adventure. That's taking place September 25th to October 10th. If you're interested in learning more about that travel program, we will also put a link to that in the chat. Welcome. If you haven't introduced yourself in the chat, please do so. We will give that to Professor Salzman when the program is over, and he's been reading along while I've been introducing him. And now I'll pass it to you, Professor Salzman. Thank you.
all right. Thank you. And I'm going to try to, it worked. Oh my gosh. Okay. Can you see the slides? Excellent. All right.
We
So
can
thank
see.
you. You all good? Great. So thank you, Lauren. Thank you, Khadija. I just wanted to start off. A lot of folks don't realize the work that goes on behind the scenes, and Lauren and her team offer just extraordinary range and number of offerings. So thank you for that. So I'm really excited to share with you today what is a growing legal movement. I want to talk about what it is and what it could mean for environmental protection. And I want to start off, as I always do, with a story. So, morning of August 2nd, 2014, the residents of Toledo, Ohio, were ordered not to use their tap water for drinking or bathing. There was a ban on contact with the city's water, and it stayed in place for 3 days. It was bad. Now, everyone knew the cause. It was pollution in Lake Erie. In the springtime, there were these huge algal blooms, and they produce toxins that contaminate the drinking water supply. Everyone knew the source of the algal blooms. It was nutrients from agricultural runoff. The nation's primary defense against water pollution, the Clean Water Act, didn't help. It has an exemption for runoff from farms, and the state wasn't taking effective measures either. So enough was enough. And concerned citizens basically thought, if there's no obvious legal tool, what can we do? And they thought, well, what if Lake Erie could defend itself? And so they started a petition campaign. They collected over 10,000 signatures for a new law. 2019, a special election adopted the Lake Erie Bill of Rights, LEBOR, as it became known, passed with over 60% of the vote, and it became part of Toledo's city charter. So what did LEBOR do? Um, Libor quite literally gave legal rights to Lake Erie and its watershed. It said Lake Erie, the watershed, possesses the right to exist, to flourish, to naturally evolve, and it granted the ecosystem the power to enforce its rights through the city of Toledo or its residents against any corporation or government actor. And what about defenses for those who were charged under the law? They were out of luck. If you read this, essentially what it's saying is that corporations charged with violating LIBOR will not be legal persons. They can't assert any defenses against the law. And it wasn't just that. The state of Ohio did not have the right to pass any laws that would weaken the rights created by LIBOR. Now, you don't need to be a lawyer to realize this law has some problems. And it was challenged very quickly struck down as well. The judge said it was unconstitutionally vague. They could have struck down efforts to strip the corporation's legal personhood. They could have said, you can't turn a supremacy clause on its head. State laws trump local, not the other way around. And as the court said, this is not a close call. So I want to suggest a puzzle for you to consider. The first puzzle. These were smart, these were savvy lawyers. So why would they propose a law that college students or high school students could tell you was unconstitutional, right? What were they thinking? It seems weird on its face. But I can tell you for one thing, they were not alone. There has been a long and steady rise of rights of nature laws in the US since Grant Township in Pennsylvania in 2006. Now, it's important to note this ends in 2023, but the line keeps going. It's important to recognize that these are all local. They're not state. They're for sure not federal. And there's a lot of enthusiasm in some quarters for rights of nature approach. David Boyd's a well-known law professor. A legal revolution that could save the world. That sounds great. But here's the thing. Every time a rights of nature law has been challenged in US courts, it has been struck down. Every time. Not one challenge has survived. So here is a second puzzle for you to puzzle over. Why is there so much enthusiasm? I mean, generally, when you bang your head against the wall and the wall doesn't move, you stop. But not here, right? Why does this enthusiasm continue when it's got such a terrible track record in US courts? And a big part of the answer is that the action isn't in the US, right? In other parts of the world, you're not actually banging your head on the wall. And in a lot of respects, as I'll talk about a bit later, the US experience is actually the outlier for rights of nature, not the norm. And so to make this a little more graphic, this may be a little hard to read. I'm not sure how well it's going to show up on your screen, but this is a graph that basically goes from 1990 to 2026, and it shows the range of different types of rights of nature initiatives around the world, everything from private sector to court decisions. And what it shows is a few things. First of all, it's a very wide range of approaches. There's been a big increase, a big jump since 2010, 2015. And it's not just court cases, it's not just statutes. Realize that in all of these situations, it's the same basic strategy. Legal personhood is being granted to some aspect of nature. And so, fingers crossed that this will work. This is supposed to show this over time. Here we go. Okay, so it starts in 2006, Grant Township. Um, and then when the action starts to move to South America, India, we'll see Australia in a little bit, New Zealand, Australia, there we go, starts to move in Europe, and it gets broader. So it turns out, as of today, you have rights of nature activities going on in every continent. Now, the origin of this lecture goes back to a course that I created and co-created and co-taught with Jill Lepore at Harvard Law School and Harvard College the past few years. For those of you who haven't been to a lot of these, at this point, you write in the chat, Harvard sucks. You don't have to, but you have the option now. I've opened the door. Um, and so the idea basically was it was a joint class, both college and law school. And Jill obviously is well known as a historian, an essayist for the New Yorker. She's also a very talented classroom teacher, and we came up with this idea for what we call the Nature Summit. And the idea basically was to divide the students into groups that would represent different interests. For Massachusetts State Constitutional Convention, maybe amend it with the Rights of Nature Amendment. So we had groups that represented Amtrak, city governments, sand and gravel, all the way to the right whale hardwood forests and pollinators. We held it the first time at the old State House in Boston. This past December, we had a larger class at the Quaker Meeting House. And the course basically was trying to address these basic questions. And I want to basically raise those in my remarks with you today, next 30, 40 minutes of lecture. So first of all, why is there so much interest now in rights of nature? What forms have they taken? How does it vary? Where have they been most successful? How do you even measure what success is? And then finally, is this a good idea? Is this something we should be excited about or not? Um, and the way I'm going to do this is I'm going to take us on a tour around the world. We're going to start in the Sierra Nevadas in California, go to the Andes in Ecuador, then New Zealand and Spain, Patagonia, and then back to Ohio. So get ready for a tour and buckle up. So here's where we start. There are two very different origin stories for rights of nature strategies. One comes from the US, so I'm going to start with that. So this is the Mineral King Valley in the Sierra Nevadas. It's driving distance from Los Angeles. In the 1970s, the Disney Corporation wanted to create a ski resort. Um, and obviously, this was unpopular. It went through a number of national parks, Kings Canyon in particular. Um, and the government agency, the Department of Interior, that granted the permit, they were sued. Enter Chris Stone. So Chris was a law professor at University of Southern California, USC, and he was writing an article when he heard about this case. And the article was called "Should Trees Have Standing?" If there are lawyers in the webinar that realize this is a kind of lame pun about whether you have standing to appear in court or not. And Chris, he made a fairly simple argument, but it was novel. And the argument essentially was that if you look at the arc of history, what you see is an expansion of legal rights. So Magna Carta extends rights from the kings to the nobles, Declaration of Independence to property owning white males, Emancipation Proclamation frees the slaves, 19th Amendment, et cetera, et cetera. His argument was that basically this expansion of rights should now move toward natural objects. Now, the historian Rod Nash had also been writing about rights of nature. The idea was in the air. So this was Chris's proposal. He's proposing quite seriously to give legal rights to natural objects in the natural environment as a whole. Now, if you think about it, his argument, there's an obvious objection. And the objection is that all of his examples are people. And Chris, obviously, a smart guy, he thought about this. He taught corporate law. And he said, look, we don't have a problem giving legal rights to companies. In fact, we give them a lot of rights, and they're not people. He then goes on to explain in detail how this can work in practice. While this was going on, the Mineral King case was working its way up in the courts, and the Supreme Court had granted cert. Coincidentally, Justice William Douglas, who was a big environmentalist, he'd agreed to write the foreword for the law review issue where Chris's article would appear. So the law review rushes the schedule, and Douglas gets the draft before the Mineral King case is argued. And we know he read the article because we have his dissent. So this is his dissent in the case, and he basically says um, that you should be able to grant standing, give legal standing upon environmental objects to sue for their own preservation. See Stone, should trees have standing. So instead of the environmental group Sierra Club, The valley should be able to sue on its own. This article proved extremely influential on scholarship around the world. This graph basically is law review articles, actually any articles, scholarly articles that cite to should trees have standing. Um, I want to highlight before I start going to other examples, one of the key objections to rights of nature, because Chris spends a lot of time in his article talking about this. And in our class, we call this the Lorax problem, right? So what does anyone remember what the Lorax says? What's the Lorax main claim? Let's see if I can see it in the chat or not, right? This is basically his big byline. Exactly. Thank you, Mohammed. I speak for the trees. Um, and so here's the question. Why should I speak for the trees instead of Lauren speak for the trees or anyone else speak for the trees? Um, and Stone's answer was guardianship. We don't have a problem having guardians speak on behalf of infants, on behalf of mentally incompetent, other classes. But that doesn't really answer the question of who the guardian should be. And the Lorax problem arises in all these different types of headings. So let's move now to New Zealand and the most famous example for rights of nature. So this is the Wanganui River Valley in the North Island of New Zealand. It's the longest navigable river in New Zealand. It's beautiful, but it has a history full of conflict. So just some quick timeline here. There's a settlement, a European British settlement established in 1840. The local tribes signed the Treaty of Waitangi. By 1845, you've got a larger settlement, but it's surrounded by a lot of Maori tribes called iwis, and there are conflicts over land, and they develop into battles. There's a truce in 1848. The government buys a piece of land, large piece of land, and it starts to assert its authority over the river. And over the next few decades, many decades, they build structures that the Maori object to. They destroy their eel weirs, they destroy their fisheries. Maori are not participating in any of these decisions. And they petition Parliament back in London. They petition courts for compensation and to recognize their land rights. The litigation goes from 1938 to 1962. It's the longest litigation in the history of New Zealand. There are major water diversions in 1958. 1975, they established a tribunal that's going to investigate specifically the Maori claims of treaty breaches. And the tribunal finds that the Crown had breached its obligations. So they set up this trust board in 1988 that's on the slide here, and they're supposed to negotiate the settlement of the claims. It's very contentious. In fact, almost 2 decades passes before they're able to come to political settlement. Here's what the problem was. The problem was the Wanganui say, the Maori, of the Wanganui tribes say, we own the river, we should control it. The government says, no, the public owns the river, they should control it. And the negotiators reach a very clever compromise. They say, how about you don't own the river and we don't own the river owns itself. Now, this actually had happened a few years earlier with a national park called Te Raroara. And this is the actual vote that you could click to approve it. And the Wanganui members vote to accept the settlement. And I'm not going to go into detail because it's fairly complicated, the structure. But the basic idea here is that the entire river system is granted legal personhood. It says Te Awatukwa will also be recognized as a legal person. The settlement grants basically different layers of advisory boards. The most important is this thing called the Te Pua Tupua. This is the Lorax problem. They basically say there will be two appointments who will speak on behalf of the river, one from the Maori, from the iwi, the other from the Crown. Ever since this was established, the government representative has actually been Maori as well. There are other advisory committees with more stakeholders, a $30 million fund for governance. It was a political compromise. And so it's important to realize that it didn't change any existing property rights. It's going forward. But still, this had never been done before. The attorney general from the time who helped negotiate this zoomed into our class, and he said the idea came from Chris Stone's writing. But here's a key point. This was acceptable to the Wanganui leaders because it was consistent with the worldview of nature, being part of the community. They did not have this Enlightenment era conception of nature being a part, something to be managed. It was much more consonant with their worldview. So this is the best known rights of nature example of legislation. What about courts? So for courts, we go to Ecuador. So this is Los Cedros. It's a remote cloud forest located in the Andes. Amazing biodiversity, one of the most biodiverse areas in the world. Hundreds of orchid species, endangered animals. This is the brown-headed spider monkey. It was declared protected forest in 1989, and that meant there was no commercial deforestation or large-scale development. That all changes in 2016. The Ecuadorian government decides to open 30% of its territory to mining, and they grant a permit for mining in the forest. So, to a certain extent, this sounds like Mineral King. Here's what's different. In 2008, the Constitution of Ecuador had been amended, and it was amended because there were some powerful indigenous political parties, and they demanded some changes. And so Article 71 creates a right of nature in the Constitution, right? So Ecuador and Bolivia at this time were the only countries that had a rights of nature in the Constitution. The indigenous groups call it Pachamama. They go on to say, what does this right mean? What does the right mean? It means that nature has the right to be restored. Nature itself, independent of the people that rely on the ecosystem, and it places an obligation on the government to prevent major impacts. So this is an important point that comes up a lot with rights of nature, which is any impact on nature some violation of the right? And you want to note here, they talk about extinction, destruction, permanent alteration. These are major changes that the Constitution protects. But the Constitution was passed in 2008. The mining concession happened in 2016, and it was granted. So what happens? What happened is the government is sued, and there are a lot of different parties, a lot of different arguments, and they fail. They lose at trial court, they lose at appellate court. It goes up to the Supreme Court, and to the surprise of everyone, Supreme Court, for the first time ever, rules that nature has constitutional rights. It says these rights are not abstract, they're enforceable, they're binding. And it worked. Within weeks of the decision, all the exploratory mining equipment and staff were removed. The mining stopped. The forest has remained extractive free. It was a huge victory at the time. And even more important, it created precedent. There are a number of other cases I could have included here, but the key point is that regularly since the decision came down, there have been cases at the local scale in Ecuador that have used the Los Cedros decision to protect mangroves, to protect rivers, to protect against a sewage discharge, hydropower. So just to give you an example, so this is a case in 2024 from the Machangara River, and this basically flows through Quito. And the court said that the river's rights were violated because it was being polluted. And it said, city, you have an obligation to basically put in sewage treatment. Um, Even more interesting, the year after that, last year, there was a big effort to hold a new constitutional convention. And the goal was to weaken these provisions, and it failed, right? In the actual vote, whether or not to hold a convention, it didn't go through. So in Ecuador, at least, in New Zealand, this is the real deal. It leaves open some important questions, though, right? So how do you balance development with ecological rights? You don't want to stop development. What remedies are appropriate? The Lorax question, who gets to speak for nature? And is it all ecosystems? Is it only the cloud forest? These are up in the air. So one thing I want you to note here, and there are other examples I could have used from Colombia, from Peru, is that these examples have strong indigenous involvement, oftentimes political involvement. The question, though, is what about places where there's not strong indigenous populations or the populations that are politically, they're not powerful? So the question is, are there examples of that? And the answer is yes. And to see that, let's go to Spain. So Mar Menor is the largest lagoon in the Mediterranean. It's located in the southeastern region. It's called Murcia. In Spain, you can see on the map here where it is. Beautiful part of the Mediterranean. It's shallow, important area for birds. It also has been changing a lot. So in 1979, there was a big water transfer project, and it led the area around it to be fully irrigated. And it's transformed Murcia into what's been called the orchard of Europe. A lot of farming. And a lot of farming also means a lot of runoff. Think back to Toledo. The area also has been basically a very attractive place for tourists. So the 13-mile sandbar that separates Mar Menor from the Mediterranean, it's just full of development, tourism, housing, marinas, artificial beaches. Um, and this led to some real problems. So starting in about 2016, over the last decade, the combination of the nutrients flowing from the ag fields, the agricultural fields, the farming, and the inadequate sewage treatment from all of these developments basically led to these enormous algal blooms. Basically, Mar Menor, the body of water, couldn't absorb the nutrients anymore. You get these massive explosions of phytoplankton. When the plankton dies, basically bacteria come over to eat it up, and they consume the oxygen and leads to what's called anoxia. Basically, the life in the area literally is choking, right? It can't breathe. And so in 2016 and 2019, literally tons of fish and crustacea ended up on shore. August 2021, there was a new anoxia incident. 4.5 tons of dead fish were on the shoreline. Not good for tourism. And I showed this picture because it was the least disturbing of all the pictures that I could find. Imagine this going back another 20 feet. There were bulldozers that basically just piled these sort of dead bodies up for burial. So this is where the story gets interesting, and it gets interesting because it has a hero, a heroine, and the heroine is an environmental law professor, which I have to tell you doesn't happen nearly often enough. This is Teresa Vicente. She taught at the law school at the University of Murcia, and she was very familiar with the examples of Wanganui, of Los Cedros, and also the writings of Chris Stone. And so this is Professor Vicente speaking in her own words. And she's saying, the wildlife was dying right in front of our eyes. Why don't we have the law that sort of takes care of this? She'd been studying grant rights to nature, and she realized we have to recognize and that the lagoon can defend itself in its own right. And so she used the students at the law school clinic to study the sort of history examples and to actually draft a law that, as with the Lake Erie Bill of Rights, would allow Mar Menor to defend itself. And what they seized upon was an option that you have in in Spanish law, which is called a popular legislative initiative. And what it means basically is if you get enough signatures on a particular draft bill, it will go to or can go to the National Assembly where they vote on it immediately and it either becomes law or doesn't become a law. They needed 500,000 signatures. This and it basically is a time period where you start the process and where it ends. So they needed 500,000 signatures. This was during COVID, right? Very hard. She talked about how she would set up these tables and people would sign them until the police would come along and order them to disperse because you couldn't have large groups coming together. And so, they had this PR, can Mar Menor have rights like people? But they weren't going to make it. And there was another huge die-off that happened in 2019. And she has this amazing way with imagery. She basically says the mass suicide, cry of suicide of thousands of fish and crustaceans jumping ashore because the water of the lagoon had become unbreathable became the cry of a citizenry. And so what happened next is quite extraordinary. In this picture, imagine this picture with 70,000 people. So 70,000 people put a human ring around most of Mar Menor during COVID, right? They're all wearing masks. And the idea was it was a sort of public hug trying to save their lagoon. And they ended up getting 640,000 signatures. They got many more signatures than they needed. I think it's a wonderful example of the rhetorical power of rights of nature, which I'll talk about a bit later. So the national legislature goes up for a vote in 2022 and it passes. It then was challenged in court. It made its way up to the courts. Last year, the Supreme Court of Spain, they approved it. They said it's fine. It's not unconstitutional. And so the law is now in good standing. It sets out in detail how personhood works, but these laws all have a very similar structure in all the places we're talking about. They grant legal personhood. They then describe what that means in terms of what the rights actually are, right to exist, right to flourish, depending on what it is. They talk about governance, which is the Lorax problem. They say what happens if a party violates the right of nature. And then they talk about sort of standing, who gets to sue on behalf of it's a Lorax part two, who gets to speak in behalf of the natural feature. You should note that this resulted in 350 million euros from the EU for restoration funding. Now, the important thing here, other than I think it's incredibly inspirational, but there's no indigenous aspect to this story. This is just, the Spaniards basically saying we love our natural environment, and we want to protect it. Um, and this also has been sort of served as inspiration for other initiatives that are being considered, particularly in Europe. So we've been moving fast, but we've looked at rights of nature initiatives in the US. We've looked at them in New Zealand. We've looked at them in Ecuador. We looked at them in Spain. I want to finish by going to Patagonia, but it's not the Patagonia at the bottom of South America. So a rights of nature approach, as I said, grants legal personhood. But what would it look like if companies thought this way, if they acted this way? So foundations, NGOs, they already can hold stock in major companies. And so, we're used to having, I don't know, a Greenpeace Sierra Club introduce a climate resolution at an Exxon shareholder meeting. Those are voted down. That's different. What would it look like if nature really had a seat in the boardroom? And it turns out that we have a clue what it would look like, and it's Patagonia. So Patagonia, we know as a clothing company, but didn't start that way. Its founder, Yvon Chouinard, started actually as a mountaineering supplying company, and the company lore is that he pivoted away from that. They had a best-selling piton, and he pivoted away from that when he grew concerned that the firm's pitons were actually harming the mountain rocks faces. He didn't think that was the business he should be in. Pivots to clothing. The rest is history. Patagonia is privately held, and Chouinard basically holds or held the stock. And about 5 years ago, he asked his lawyers, his company lawyers, to find a way to quite literally make the earth a shareholder. We had his general counsel and some of the lawyers zoom into our class, and that's literally what they said. He went into his office and said, "I want the earth to be a shareholder." Um, Now, there were several challenges to doing this. One of them is that the fiduciary duty of a board is to make profits. The duty is not to protect the earth. So how do they deal with these? Well, without getting too technical, the first thing they did is they registered the company as what's called a B corporation, certified B corporation or benefit corporation. This was the first company in California where that happened, and it allows firms to have an explicitly social or environmental mission. So what they did, and again, I'm oversimplifying, but they basically divided the stock into voting shares with with no dividends and non-voting shares with dividends. The voting shares that basically don't have any profits, they're held by what's called the purpose trust. And they literally are supposed to act with the purpose of overseeing company management, subject to the long-term mission that the company describes as, quote, saving our home planet. They're the sort of board that you expect in a corporation. But 98% of the non-voting stock is held by something called a holdfast collective. They spend all of Patagonia's profits. They spend it for environmental advocacy. They spend it for protection. It's over $100 million a year. So it's not literally nature in the boardroom, but it's close. And I personally find it quite inspiring and quite creative. So we've now gone on really a whirlwind tour. Um, and I want to make clear, I could equally have described examples from Australia, from India, from Canada, from Colombia, from Peru. Um, Many of these have been successful, some less so, some have failed. The key point is that all these initiatives start with the same move, which you grant legal personhood to nature. And once that happens, the game's afoot. There's enormous variety, enormous creativity, and this movement is happening in real time. So, what are some of the key points we can take away? What I want to do now, in drawing this to a close, is suggest some of the different strategies that are driving rights of nature and realize that these are not mutually exclusive. So why are we seeing rights of nature initiatives? One reason, to be candid, is virtue signaling. Right. This is a ordinance that was adopted by the city of Santa Monica in 2019. It says natural ecosystems have a fundamental and inalienable right to exist and flourish in the city of Santa Monica. Um, you may be shocked to hear that Santa Monica could be virtue signaling. I found it hard to believe. But the fact is, there are a fair number of local governments that are looking for slogans. And as of last year, we checked, um, and the provision has never been used. The key point here is that the laws are popular, they're low cost, but little is expected and little will result from that. More substantively, you have rights of nature as a legal campaign. This is Los Cedros. There are other examples I could have given. In this situation, there are attorneys who are making their case before a court. They might be trying to make constitutional provisions meaningful. They might be trying to persuade judges to apply what law there is creatively. There are real questions with this approach. So one is, even if the court rules in your favor, will the remedies be carried out? That's been a big issue in Colombia with the Atrato River. Or if the court grants this right of nature, recognize the right of nature, will it be struck down by a higher court? That's what happened with the Ganges and the Yamuna in India. The US, because I know there'll be questions about this. In the US, standing doctrine is a major barrier. Standing basically describes whether or not you can go to court to press your claim. And just to give you an example of this, in 2017, there was a lawsuit that was filed in federal district court on behalf of the Colorado River ecosystem. It was explicitly a rights of nature approach. The judge threatened the lawyer with Rule 11 sanctions under the Federal Rules of Civil Procedure. That's bad. The lawyer quickly apologized, withdrew the case, right? That judge, at least, and I think many others, are not going to look positively toward this approach. To be honest, I think it's fair to say that most US law professors, certainly I think most environmental law professors, are skeptical about rights of nature. And I don't see a lot of rights of nature being successful in US courts in the near future. But I think that risks missing a larger and maybe more important point. So let's go back to our original puzzle. So why did lawyers go ahead in Toledo with a law that was clearly unconstitutional? And the answer, I think, in part is maybe we're looking in the wrong court. And what I mean by that is you can lose in the court of law, but still win in the court of public opinion. So here's the follow-up that wasn't reported. There was a lot of media attention over Lepore, and as a result, the governor of Ohio, Mike DeWine, created a statewide initiative focused on addressing water quality, and a cool name, H2 Ohio. And the very first grant from that program went to, you guessed it, the Toledo watershed to reduce agricultural runoff. And so essentially what happened, and I've spoken with the lawyers who were behind this. They haven't said this explicitly, but I have to think that a large part of their strategy was to make this politically salient. They used the rhetorical power and support from rights of nature to motivate politicians. It's rights of nature lawsuits as a means to an end. Now, I should say I have concerns about this approach, and I'm happy to talk about them in the Q&A, but this clearly is part of a strategy that's happening. Rights of nature is community empowerment. So look at Mar Menor, right? Mar Menor is clearly a political strategy, but it's also a community empowerment strategy. I mean, the image of 70,000 people holding hands around a lagoon, I just think it's powerful. And it's undeniable that the idea of rights of nature captures the imagination. It speaks to a lot of different kinds of people about the way things should be. It motivates people. The brilliant insight, I think, that resolved the Wanganui conflict, this is the sort of bringing the indigenous aspect, was that the river could own itself. So they bypassed the competing claims. They focused on shared governance that was consistent with a Maori worldview. And basically, if you look at the examples around the world, some clearly are inspired by indigenous groups, indigenous traditions, some not at all, right? Rights of nature is not a single movement, right? There are a lot of different ways it's being used. Personally, I think that this approach could have real promise in the US for how we think about traditional Native American lands that are held by the US government. There's something called the Land Back movement that is trying to basically literally get the government to give the lands back. That seems unlikely to achieve its goals, but one could easily see some kind of shared governance structure, like we saw in Te Raroara, like we saw with Wanganui, other examples as well, arising not in this administration, but in different administrations. You could certainly imagine that. So what's it all mean? What's it all mean? So let me leave you with three parting thoughts, and then we can get into the Q&A. One, rights of nature is not going away. By any measure, the explosion of interest around the globe in rights of nature forces environmental law to sit up and take notice. There are examples outside the US with real laws, with real teeth. Words matter, right? The phrase rights of nature holds a rhetorical power. It makes it makes an emotional connection with the need, with the responsibility to protect our natural world that environmental law simply does not. This is an approach that excites people. And there's a particular group that it excites, and this became really clear to me teaching this course the last few years. I think many of our students' interest in learning about rights of nature comes fundamentally from a sense of frustration. The impacts of climate change, loss of biodiversity, they're getting worse. And quite frankly, our environmental laws have failed to address these adequately, and the younger generations are fed up. They're looking for new approaches, and rights of nature offers that promise, that hope. And it sounds corny, but ultimately, I think this is about hope. And the term's very looseness, its unrealized potential, I think makes it all the more enticing. And finally, we may be living in a moment. So if one looks at the history of American environmental law, there have been very distinct periods. There was a conservation movement of the early 20th century. There was environmental movement in the 1970s, environmental justice in the 1980s, and partisanship and polarization and largely gridlock from the 1990s on. What makes rights of nature especially exciting for me to teach and to study is the impossibility of knowing if this is simply a fad that will soon pass or if it's much more. I don't know. Jill doesn't know. No one does. This is a fast moving field. Now, there is a lot of hype, to be sure, but it may well be that 10, 20 years from now, we will look back at what proved to the beginnings of the rights of nature period. And all I can say is stay tuned. So with that, Lauren, let me pass it back to you, and we can go to the Q&A.
Oh, I'm here. I'm here. All right. There we are. Hi, everybody. Okay, let's go to the Q&A. We already have a lot of questions here, but please do post your question in the Q&A and not in the chat because that's the easiest way for me to keep track of it. Okay, I want to start with Douglas. He says, if rampant development threatens or actually results in species or subspecies extinction, can the activity be considered in some way a genocide and therefore prosecuted as such under international law? There's a
The answer,
follow-up, but I'll start
yeah.
with that because
Okay,
that's pretty heavy already.
is that heavy enough? Well, you really start with a big one. The answer is under today's law, no. Right? I mean, there is the Genocide Convention, and nature aspects of nature clearly are not part of that. In order for that argument to work, you have to basically give rights of nature. You have to grant legal personhood. Um, and so, in terms of today's laws, the answer is no. Could one imagine a world where that was possible? For sure. I mean, there's a lot of interest among academics, some civil society groups about a notion called ecocide, which I think is really what you're getting at. And the question is, can ecocide be regarded as a violation of international law? The answer is not yet. But this is how these things happen. They start with an idea that may seem crazy. Um, but over time, as scholars write about it, people talk about it, presentations on it, um, it starts to seem, a lot less crazy. That really is Chris Stone's argument. right? I mean, any of those things, giving nobles rights, outrageous, right? But over time, these things become normalized, and you look back and say, how is it that we didn't give them rights? How did that ever, how was it ever a thing?
Well, and I've been reading the introductions in the chat, and we have so many people here from all walks of the different sides of this issue. And you and I were chatting before the presentation on, the last time we talked about water rights and when your book Mine was released, we touched on this, but I feel like even since then, it's the topic has just gained momentum. Just looking at it, I mean, here in the today's presentation, we have lawyers, we have activists, we have scholars, we have students who are working on graduate research on this topic. We have armchair citizenry who are trying to protect their local bodies of water and also landscapes. It's just a broad spectrum of folks working on this. And what struck me, especially looking at your image from Spain of all those people who showed up, and held hands around the shoreline, is I want to get to the second half of Douglas's question because it strikes me that part of it is the connection with the rights of the water, but the other part of it is that there really isn't a lot of boundary between those rights and humanity's rights to enjoy those bodies
Hmm.
of water and to
Yeah.
to live off of things like the fish who are committing mass suicide, right? So I want to go to the second half here. Douglas says, since the despoiling of nature threatens our own species' existence, why not consider these issues as crimes against humanity? So if we can't call them genocides, could we pursue them as crimes against humanity?
I think we're kind of in the same ballpark as what I said before. So let me pivot a little bit and build off that question, also what you said. So there is a strong movement for something that is allied but different, and that's a right to a healthy environment uh, and a constitutional right to a healthy environment. That's much more common. There are, I think it's four or five states in America that have a right to a healthy environment in their constitution. Montana, a case called Held that came down a year or two ago, basically upheld that right in terms of environmental impact statements. And so, again, there are two ways I think to go at rights of nature. One is sort of ethically, should nature have rights? One is instrumentally, which is I want to protect this body of water. I want to protect this particular aspect of nature. What's the best way to do it? Um, and it may be that sort of quasi rights of nature, like right to a healthy environment, is a way to get there. Rights of nature is not going to work in Montana. Right to a healthy environment could. Right. So a lawyer basically, not just lawyer, any advocate, takes what she has at hand and says, how can I advance the cause here? Um, but I want to be so a right to healthy environment. A lot of these amendments also were adopted in the 1970s. I mean, it's important to realize I was talking about periods. 1970s, that decade was an extraordinary period, right? All the major U.S. environmental legislation was passed in 10 years. And what I find interesting, I think Jill finds this interesting as well, is maybe we're in that kind of period right now with rights of nature. I mean, if you look at the uptick in the graph that I showed you, there's something going on. Um, it's challenging to make it practical, but you do get the sense that there's some kind of conceptual shift that's taking place, and this idea doesn't seem so crazy.
Okay, well, there are the great thing about getting together a Yale community as we have today is there are a lot of different ideas about how to come at this. So lots of questions about what about this way, what about that way. I want to speak to kind of it's not one person in particular, but a few folks have said, you know, do we go at this from the standpoint of states and local municipalities and try to gain traction there? In terms of having those kinds of laws changed? Or do we go more from a federal perspective? And sort of what are the pros and cons of looking at it in these two different ways?
Yeah, that's easy. You can swing for the fences, but you'll strike out. Every single rights of nature initiative in the U.S. to date has been local. Um, and it makes sense, right? I mean, think again about the sort of communal embrace of Ma Manor. People are inspired, they're energized because they care about their local environment and they feel an ethical obligation, they feel a connection, a moral connection to that. Um, and so I think in terms of strategy, you absolutely want to start local. Um, the question in the US is what can you do legally um, that will actually give it some teeth, or learning from Libor and Toledo, maybe it's a mistake to think about this like a lawyer, and instead you should think about it as an advocate. And you can energize people. You can get it's basically rights of nature's community as community organizing and community empowerment. It's powerful, right? I mean, it can work. Um, and so my own view is that in the U.S. at least, there's going to be a lot more advancement with rights of nature as community empowerment and getting people engaged and caring than about winning in the courtroom in a meaningful way.
Well, on that topic, I want to just go to a sort of second tier to that question that has been percolating here with all the questions in the Q&A, is just the idea of whether or not there are, as Lewis says, patterns or characteristics of other countries where the strategy has been more successful or less successful. What are the kind of key elements you would identify? So, maybe we can look to what's happening in some places. And I think you spoke to this a bit when you talked about how indigenous worldviews come to bear on presenting ideas that are effective in legislating this. But if you wanted to speak
Yeah,
more about sort of other
sure.
areas in other countries.
Yeah, sure. It's a good question. And again, just to give the sort of the key point up front, there is no rights of nature strategy, right? Rights of nature starts with a legal move, which is giving legal personhood, and after that, it just goes in so many different directions based on not just local conditions, but what the locals want. So let me give you two examples, one that I didn't talk about, one from Canada and one from Australia. Um, so the Yarra River flows through Melbourne in Australia. And there was a statute that was passed that basically created a Yarra River Council. And basically, it's a whole range of stakeholders from sort of businesses and water users uh, to the um, to the sort of Aboriginal tribes that have lived there since time immemorial. I think is the phrase they use. Um, and they basically, I'm simplifying things, but essentially they make management decisions for how the Yarra River watershed should be managed. The decisions are not binding, but if they're not adopted by the government has to justify why they were not adopted. Right. So governance is a big part of this. Again, if you want it to have teeth instead of simply to get people interested or excited about it. Second example is in northern Quebec, Magpie River. So this is a case where the First Nation, right, the Native Americans, the tribe there, um, they basically granted legal personhood to the Magpie River, but they did so in coordination with the local government, and so they passed these sort of complementary resolutions at the same time. And so one sort of complements the other. And so what the tribe wanted essentially was adopted by the local government. And they're working very closely together. And so those, I think, are great examples where you see rights of nature as very much giving legal voice of one form or another to an indigenous culture, indigenous population.
Well, I'm glad you brought up the Canadian example because there are quite a few Canadians in our Zoom room today from all different places. And I believe Maria, let me see if I can get back to your question, Maria. Yeah, Maria asked if you could speak to what's going on in Canada regarding rights of nature legal efforts. So you've just given an example from Quebec, but I wonder if you wanted to say anything else more broadly. There's a very strong sort of First Nations emphasis and focus and dialogue with the federal government and with the provincial governments in Canada. So wondered if you wanted to say any more about that.
Yeah, well, the first thing I want to say is I'm not an expert about this issue in Canada, so take what I say with a big grain of salt. I think this sort of raises the bigger issue, which is what rights of nature can allow you to do is to be very creative with governance, right? Rights of nature basically, in a sense, it's the Patagonia discussion I had at the end feeds into this because the whole point of the rights of nature in the boardroom, nature in the boardroom, some of these other examples is that you think about resource governance, resource management differently if nature is having a voice in the decision. So, the way we do natural resource management now is we have stakeholders. Um, but the fact is, the friends of the Yarra River, right? The friends of the puma, the friends of the condor, they represent as best they can the interests, but they're not really thinking what would the condor say. Right? What they're thinking is what would help my group promote the interest that we have to save this particular aspect of nature. And what's happening in Canada with these discussions they're talking about is you think about it differently if there is literally a voice in the decision-making process saying, this is what nature wants, right? You approach the problem differently, you think about it differently. So instead of having to be interest group advocacy, which is essentially how resources are managed right now, um, you think differently, saying what is the ecosystem itself care about? And it's a very, I can tell you, I teach natural resources law, I write about it. It's a totally different way of thinking about the issue. So that's sort of how I would get at it.
Okay, lots of interesting questions still coming in. Um, I'm just thinking about which direction do I want to go in. I think I want to go in just sort of Sarah's question sort of symbolically speaks to something that I'm sure a lot of people are interested in. There are a lot of advocates on this call, people who are actively working to address particular natural resources. And Sarah says, where do I start to establish the 8,000 acres I steward in northern New Mexico as having legal personhood? But I think that abstracts to the larger question of what can people do if they are actively involved in this
Mhm.
in their local communities? What are some steps they can take that are effective?
Yeah, it's something I think most everyone cares about if you have a connection, feel a connection to the natural world. Um, and I'm going to answer not as an environmental advocate, but strictly the rights of nature prism. And I think the thing to do, if I were offering advice modestly, um, is to think about rights of nature as political, as community, rather than as litigation. Right. So what that means is essentially getting the local decision makers, local politicians involved and saying, what do you think about an ordinance that would grant rights of nature? What would that mean? Um, Now you want to think about that, right? Because because you give nature a right, then you say, okay, well, what does the right mean? I mean, it doesn't. If you give rights of nature to, I don't know, to the Marmanor Basin, it doesn't mean that they can vote, right? And so, what I would recommend is in terms of raising the profile of the issue, I think granting rights of nature is proven to be effective. But then what does that mean? Does it mean that you basically try to address the Lorax problem and say this group will speak on behalf of their interests and the county board agrees to consider that in their deliberations? Or, I mean, there's so many different ways you can go with this that doesn't give you something that'll just be slapped down by the courts. But I think the short answer is in the US, rights of nature is most powerful in the court of public opinion. And so the way to do it is to help sort of frame people's perspectives of basically thinking about this differently. Think, hey, our local watershed should have rights. And if it did, how would they be expressed? Not sue the bastard.
Okay, well, speaking of that ethos,
Which,
the sue the bastard ethos, I want to go to Jennifer's questions about the corporations, and I want to use it
Mhm.
to to speak to a couple of different questions that have come in. Jennifer says, if corporations have had personhood for so long, it seemed like personhood for nature, which the public would mostly support, hasn't been established. And I think that was sort of presented, that, but Jennifer speaks for a lot of folks here who said it just seems sort of obvious that if corporations have personhood, then nature should have personhood. there was a very lively discussion in the chat, I think somewhat led by David Liu, who's since logged off, to speak about the sort of Western, and you addressed it as well earlier, the sort of Western worldview that sees a dichotomy between human life and natural life in ways that sort of indigenous worldviews don't.
Hmm.
Um, and then there are folks who are bringing up personhood for nature could be then a door opening to personhood for other things.
Yes.
So, what about personhood for animals? Um, what about personhood for other aspects of nature, not just water or bodies of land? So, I've thrown
A
out a
lot there.
lot of things to give
Yeah.
you threads to pull on
Yeah.
and see which way you
Um,
want to go with them.
let me go with just two or three, and then it can sort of go its own. So let me talk quickly about animal rights and rights of nature, because those two often are conflated and they're different. Um, so animal rights is this actually is how I met Jill. She was writing a draft of this article that became the Happy the Elephant piece in the Atlantic, and she was talking in the piece about both rights of nature and animal rights and environmentalists. And I said, look, these are different, and in fact, animal rights folks and environmentalists oftentimes don't like each other, right? They're oftentimes on different sides of the same issue. Um, and so animal rights is focused on oftentimes on welfare, on sentience. They're focused on individuals. Rights of nature is focused on systems, communities, right? So for those of you who know their environmental ethics history, Aldo Leopold is very much a rights of nature kind of kind of person. And this becomes important because these are two groups that really can be allies. But take some examples. So, for instance, the example you used in class was basically wild burros and horses in the Intermountain West, right? These have been here since the Spanish times, very destructive to the soil, destructive to a lot of the vegetation and such. Um, and a lot of environmentalists want to take them off. A lot of animal rights people want to keep them on. And we had a great discussion in class. And I'm curious, kind of what folks in the chat think about this. What's the rights of nature perspective on this? Right? And so is it that the horses have their own rights, and so it's right versus right, or is it, basically the ecosystem? And what it comes down to, and it's why I actually listed what the elements of the law were. For mar minor, you have to identify who the right holder is, who the right bearer is, because that determines everything. If the bearer of the right is the mar minor lagoon, then individual fish are not rights bearers, right? And if the sort of Intermountain West ecosystem, the high plains, then the individual horses don't. So that's sort of one sort of quick thing. In terms, although there's a case in Ecuador called Estrelita, which some folks may know about, that extended the rights of nature logic to an individual monkey. So, they can overlap. Um, where there's a lot of interest right now is robot rights, right? And I saw there was a mention in the chat about AI, and we've all basically what was it called Her. There are a bunch of movies that are out that basically, the AI seems to take on its own sort of sentience, its own consciousness. I think of that as much closer to animal rights than rights of nature, but it's on the same tree, right? Might be a different branch. But there is this question, and it's similar to Lorax, which is how do you draw a line? Right? How far does the rights of nature extend? Is it the river? Is it the river watershed? Does it go farther than that? Those are difficult choices. Last thing I'll say about corporations, because I could give a just I go on. I mean, those are big questions you've raised. Is look, I mean, you'd have to live under a rock, not to realize that one of the main reasons corporations have such healthy legal rights is because of corporate lobbying. Um, and that hasn't happened with rights of nature. Could it? Maybe, maybe. I mean, if enough sort of voters think this is important, it will happen. Um, but you're not going to have necessarily moneyed interests that are pushing it forward. Oh, you're muted, Lauren.
There we go. I pressed the wrong button. There we go. That response in and of itself has a whole additional hour of discussion. corporate lobbying and how that would work versus versus community activism. It's just a very interesting thing to consider. I want to go esoteric for a minute because there are a few people who have done this, and I think you alluded to it in what you just said when you spoke about animals, rights for animals, and sort of comparing them to rights for different aspects of nature. You really were circling around the idea of sentience. And right, because I think it's very easy for people to recognize the suffering of a sentient entity and then confer rights to it to alleviate its suffering. And this is something that came up in the chat as well. But I want to use that to get at Gabriella's question. Gabriella says, when thinking about the Wanganui, I'm going to say it wrong, river,
When can I?
Wanganui, thank you. I wasn't that far off.
No.
As a political compromise consistent with Maori worldviews, do you have any concerns about how this requires indigenous actors to translate themselves and their ways of being, and I would say ways of knowing, into Western laws, which can't actually grapple with the ontological depth of
Yeah.
recognizing, Gabriella says recognizing a river as an ancestor or kin, but I would also say recognizing a river or a part of nature as having sentience, because I think that it would turn more clearly for us on the idea that these things can be sentient. And that's where there's a real distinction in a Western worldview and an indigenous worldview.
Yeah, no, that's really interesting. I actually would push back on that. I'd agree and push back.
Ooh, I love
Um,
pushback. All right, we're getting a debate.
so I don't think sentience is where the action is. But let me go back actually to the first point because that's a sort of profound point, and yours raises different profound issues. So it was Gabriella, um, and so she's right. I mean, you basically the indigenous rights are existing in a conqueror's world, right? These are sub-nations within a nation, sometimes treated that way, sometimes not. And so they have to basically accommodate themselves to the not the dominant, to the legal paradigm that operates. And so absolutely. The indigenous groups, legal system, cultures, customs, practices, if they're going to be given legal force, they're going to have to accommodate themselves. Um, and that's just it's a necessity. That said, one can go pretty far along that path, and a lot traditionally it hasn't gone at all, right? And so so if you compare it to what it might look like and where it has been, I consider the Wanganui, Te Urewara, the Pachamama. I think it's going a long way, and historically it's going a very long way since sort of since the Columbian conquest. So that's sort of how I think that she's right. That it's a fundamental problem, and so one does what one can in that system. The sentience, I actually think that it's conflating animal rights and rights of nature. So if you look at the actual statutes that talk about what are the rights that are granted by legal personhood, they will talk about intrinsic value, natural processes, the right to flourish, the right to exist, the right to evolve. None of that has anything to do with sentience. Animal rights is all about sentience. Now, for sure, I'm certain there are a lot of indigenous traditions that view aspects of nature as having sentience. But in terms of how the laws are written, sentience is not part of the calculation. It's not a qualifying aspect. And interestingly, you look to Mar Menor. If you asked the 70,000, I would think very few would describe Mar Menor as a sentient aspect of nature, but they still feel a close connection to it.
And probably recognize somewhat the suffering of, the death of all of those fish,
And this
right?
and that phrase, this sort of suicide. I
Right,
mean, what an image. And they did. To get air, they leapt onto the beach.
right. And I think that's kind of another interesting point that you made is whether or not that's in alignment with their belief. It's a rhetorical strategy that the professor used to frame it that way that allowed people to connect with the suffering of the fish and
Yeah.
perhaps gave some momentum to their movement.
The environmental law professor, not just any
Hmm.
professor.
Right. Yes. Um, okay, there are a lot of, speaking of environmental law and the more technical aspects of the law, there are a couple of questions here. Um, I think I want to follow up on this, just what we've been talking about with some, they didn't name themselves, but they said, would rights of nature's imputation of legal rights to natural entities run the risk of bolstering other non-person claims, such as most consequently, Citizens United?
Well, to make it even more provocative, which is fetuses, right? So this is something the animal rights movement is concerned about. Um, and this is sort of one of the criticisms of Stone's argument is that once you start granting rights, be it beyond sort of independent people, where do you stop, right? What's the limiting principle? And it's a fair question, right? Some people may think it shouldn't go that far, and you say, well, why? And you're on shifting sands if you say it should go to a watershed, but not to, you know, whether AI or a fetus or whatever, whatever object. Um, and I think that's why certainly for a lot of law professors it gives them pause. They're all into limiting principles. Um, and so, I think an interesting question, we asked about it in our class and we didn't get sort of a definitive answer. Why should a river have rights? And, maybe the answer is because we are the ones that respect rights and we think they should. And so we're going to regard them accordingly. So whether the river has rights or not doesn't really matter. What matters is whether we think we should accord them that type of treatment, which strikes me as a little circular. But that's sort of the argument. But this is it's a long-winded answer, but it's a very I find it a very hard problem.
Well, let's look at it from the standpoint of the Colorado River. So there's been a lot of chat about the Colorado River. And one of the sort of someone's question is a bit more generic, but I think it applies to the example of the Colorado River is um, creating rights of nature for one state when the river, for example, spans multiple states and
Hmm.
has different purposes in the places where in the other states where it shows up.
Hmm.
And Williams says, what would happen if you gave rights, for example, to the Colorado River, where water rights of a different but legal and practical nature are already in place for the landholders with water rights?
Hmm.
Isn't
Hmm.
it entirely academic in nature since there is the insistence of the upper basin rights holders holding on to their water, making it much harder to meet our obligation and send a certain amount of water to the Colorado Delta and to Mexico?
Right. So let me get at that three different ways. The way that I think, I mean, it can be technical, which is to say you don't need to go rights of nature to talk about the issue of allocation of Colorado River water. I mean, the way that, I mean, the Colorado Compact is sort of its own universe. Let me give you, though, a different story I didn't talk about that I think will illuminate this problem more fully. Because again, Colorado's got such its own history. So the Ojibwe tribe in Minnesota, um, they have a very close relationship with what's called Manoomin rice. It's a kind of rice you get from a plant that grows in the wetlands, and they basically use that for a lot of their. They use the rice obviously for their diet. They use the reeds for all kinds of things as well. They on their reservation granted Manoomin rice a right, legal personhood. They tried to use that then to challenge pollution and water management upstream of their reservation, and they lost in court. And this is sort of a big aspect of Indian law, which is that there are very few ways that tribes can control activities outside their reservation. And environmental laws is one of those. And so it's a similar kind of a jurisdictional problem. which is you can sort of establish a right of nature, but it's hard to control activities that affect you that are upstream or otherwise placed that have different jurisdictions. And so this is something, I mean, there are a bunch of tribes that actually have and are establishing rights of nature within their tribal jurisdictions. The challenge is extending that outside to change behavior that actually impacts the nature inside the reservation.
Okay. Yeah, that sounds like also a whole additional presentation.
It's a great course. That's right.
Um, s- uh, this is a very broad question, but I think it's an interesting one to consider. And I want to say for everyone's benefit who's still here that um, Yale Alumni Academy has for quite a long time done presentations that support the scholarship of our School of the Environment at Yale. And so we have over 25 of these recorded presentations available on our website on demand. This presentation will also be added to that cluster and available on demand. So if you're interested in these kinds of topics, please do make sure you follow our YouTube channel and check out our website regularly so that you can watch this and many, many other really high quality presentations. Um, so someone asked on the kind of theme of climate and environment more broadly, if rights of nature can be sort of a tool in the arsenal of combating climate change and how you think it might affect the overall issue and challenge of dealing with climate change.
Yeah, the students are really interested in this as well. Obviously, they care a lot about climate change. Unfortunately, it's hard to see how. And the reason is when you look at the actual rights of nature initiatives, they're always very specific. They're always place-based. Um, and so the challenge is the attenuated causation between greenhouse gas emissions on the one hand and the impact that's felt locally. And so, rights of nature is very easy, conceptually and practically to apply to stop mining, to stop clear-cut logging, to stop overfishing, right? That's very different than trying to stop the emissions of a particular facility and you know this better than I do, is emissions will basically mix in the atmosphere, et cetera, et cetera, et cetera. So to date, I'm not aware of any rights of nature initiatives that have meaningfully addressed climate change.
It's kind of counterintuitive, isn't it? I mean, you would think that it would be a great strategy for addressing climate change, but you make it very clear and easy to understand why it's a lot more complicated than that. And you mentioned that, students in your classrooms are always sort of interested in that question. I want to go to Nick's question. Nick says, speaking of youth frustration, how can rights of nature intertwine with Juliana versus Obama in the courts?
Right. So Juliana case has a number of different things going on. One of them was a rights-based argument. And I think the fact that the courts, like the higher courts, have been so and basically just take a step back for folks who don't know the Juliana litigation. Um, Basically, it was a sort of a range of legal arguments that was brought by sort of a young plaintiffs, next generation plaintiffs, talking about, is there an atmospheric public trust? Is there a right to atmospheric health? There were a bunch of other things as well, and it really they got some interest in the by the trial judge, but the appellate court really just and the Supreme Court was incredibly hostile. And I think it just goes to show that we are not at a place right now where these large claims, this goes back to the question earlier about federal versus local. We're just not in a place, both politically and in terms of the jurisprudence, where those types of claims are going to get a lot of purchase. And so, so my view is basically that, okay, let's move to where it does a purchase and build from there.
Okay. We still got 20 questions. So we can play 20
Right?
questions
Animal,
for
vegetable, and mineral. Right?
in our last.
Yeah, right. Rights of nature protects all three, right?
And some of them are quite long and That's good. Like your questions are so thorough and complicated, and it's just wonderful how you all have shown up today. It's just hard for me to pick which way do I want to go. Next, I want to address what Douglas just posted in the Q&A, which is that as much as this has been a marvelous and provocative and in some ways Douglas says deeply disturbing conversation, that in addition to the recommended readings that we gave at registration time, if you had another reading list, and Douglas is commenting on the many readings that were suggested in the chat. So that we would share another reading list coming out of some of the kinds of questions. And certainly we would be happy to. And that question gives me an opportunity to say that these presentations live on the Yale Alumni Academy website, as does a link to Professor Salzman's book, Mine, which you can buy a signed copy. He's very graciously signed book plates for you, and they are available for sale at the Yale bookstore. Um, and Professor Salzman is also leading a Yale group on a cruise Singapore to Bali, which is taking place this fall, September 25th to October 10th. So if you're really interested in bending his ear with lots more questions and challenging legal debates, you're welcome to find out more about that program. We've put the link in the chat. You can also email us at alumniacademy@yale.edu. Since I've mentioned that, I want to go to Jessica's question, which is really kind of gets at some of the practicalities of just the world that we live in. Because tourism is such a big a part of world economies these days. And particularly when we think about cruise ships and some of these places where cruising is important. I mean, the Mar Menor example was powerful, not just because of the ecological side of it, but because people wanted to enjoy the water.
Mhm.
And when it was clear that they couldn't, the impulse to do something about it becomes stronger, right? So Jessica wants to think about what responsibilities should the tourism industry have in terms of cruises and water having rights and thinking about the ecological impact of international tourism.
Yeah, or domestic. I don't think you need
Yes.
to go to rights, a rights-based approach to say what Jessica's pointing out is absolutely right. And it's a market, and what matters is that the clients care. And so clients like alumni, like other alumni groups, other travel groups, basically say, "What are you doing to improve sustainability?" And to their credit, a number of cruise lines have actually done quite a bit. They could do more. I think the pressure needs to stay on. We're coming close to a close, so I did want to sort of react to one thing. I forget who it was we just mentioned. He said that he found the presentation disturbing. I don't find rights of nature disturbing. I mean, maybe because my career has been in environmental law, um, but it's always a battle, right? There is no silver bullet to protecting the environment, and it's push forward and you're pushed back. Right now we're in an era where there's a lot of pushback, and that's just the nature of the field. I think rights of nature is an arrow in the quiver, and it's one we didn't have before. I'm going to stop the metaphor there about the arrow getting longer or sharper, but you get my point. This is a tool, and it's going to be effective in certain settings. And the key is to better understand which settings, in which form is it most powerful, and then to really use it. And the other thing is to change the conditions so that people are more accepting of this type of approach. But I don't find the fact that rights of nature is not the silver bullet to me is not disturbing at all. I find it mostly hopeful. In the U.S., it's tough, but look at what's happening in Ecuador. Look what happened at Mar Menor. The other places around the world, it's real. Um, it's not, the dominant paradigm. It may never be. That was my point at the end of the lecture. But it's a fast-moving field, and that gives me a lot of hope.
Yeah, I think you're making a really good broad point that one could take from this discussion is, that we've had property rights, and someone has said this in the Q&A as well. There's property rights have been around in Western legal constructs for quite a while. Human rights are something that I think there's a legal understanding, but how to give rights to um, natural landscapes and natural entities is not something that has a long-standing history in Western constructs. And that's really what you're talking about is bringing another, as you said, arrow into the quiver and fighting for that, just like all those other kinds of rights had to be fought for. Um, all right,
And not just fought for. I mean, thought for
thought
what?
through.
How does it even work? Yeah.
Right, right. I mean, this is why people should come and take your classes. Um, there's so many things that in this, I'm trying to pick a good one for us to end on. I want to go to Perry's because Perry's question has been here for a while, and I believe Perry, you're still here. Yep. So Perry says, do you see legal personhood of nature as mainly a rhetorical ploy or instrumental strategy, or do you think it has some metaphysical substance to it? If the latter, might it help to look to the philosophical literature on personhood as well? Um, just to cite two examples, Martin Buber's discussion of trees in I and Thou, and two, the law in India regarding the legal personhood of Hindu idols.
That's such a perfect question to end on because it's a perfect Yaley question, right? It's like let's draw on knowledge from around the world and sort of get to the core of it. So that was
Yes, and we
perfect. So
managed to get the phrase Hindu idols into the discussion today.
so thank you for that. So my answer is E, all of the above. And I'm serious. The one take-home message I would take from this presentation is that rights of nature is taking many different forms, and it will take many different forms, and it's going to look different in parts of India than it will in Spain, than it will in Peru, right? This really is kind of a homegrown strategy. And so, you know, one of the things that's so I find so fascinating about it is they're different, right? There's no sort of single rights of nature approach. And so, as I said, you know, a number of times, start with the legal move. If we give aspects of nature legal personhood, what flows from that? And I think that's really the way to think about this. But I think it's been terrific. Thank you, Lauren, and thank you for those who've joined. They've been great questions.
Thank you so much. We really appreciate you being part of the community, and showing our global Yale alumni community and all of their friends and family the wealth of scholarship and research that comes out of our Yale alumni network. And certainly, although you're not faculty at Yale, the work that you're doing definitely reflects the kinds of things that go on at Yale's School of the Environment. So we appreciate you bringing something to the table that has so many different valuable angles. I have put another link in the chat to your book. So if you didn't see it earlier and you'd like to get a copy, the book is mine, How the Hidden Rules of Ownership Control Our Lives. And we have a link to get a signed copy from the Yale bookstore. So do check it out. If you'd like to travel with Professor Salzman, you can email us at alumniacademy.yale.edu. And we're always happy to hear from you. And we will do more of these presentations on lots of different topics and hopefully have you back again in the future, Professor Salzman. So
I
thank
look
you.
forward to that. Thanks so much.
Thank you, everyone. Bye bye.